I do have skills that make me a nightmare for people like you.
Hello, darkness, my old friend. I've come to talk with you again.
The defendant, Mr. Keane, seeks costs pursuant to Costs in Criminal Cases Act 1967. A somewhat abbreviated summary as to the events leading up to my order that the charge be dismissed by consent is necessary. The one charge relating to an allegation that Mr. Keane exceeded a speed limit of 80 kilometers per hour by virtue of a speed camera. The infringement fee was $80. Normally, a case such as this would be heard by justices of the peace, but apparently, due to the perceived technical issues, it turned up in this court by way of a defendant judge-alone trial. There seems to have been some procedural difficulties in various appearances prior to eventually reaching me. Mr. Keane considered that he had not had proper disclosure and did not enter a plea. A not guilty plea was entered by Judge Black. The matter originally came before me on the 7th of November 2017. Mr. Keane raised various issues regarding disclosure and the sufficiency of the evidence that the prosecution had to bring the charge. After hearing argument from the parties, I adjourned the hearing in order that full disclosure could be provided to Mr. Keane, if it had not already been provided, and for Mr. Keane to produce various emails that he referred to. I also appointed Mr. Chambers as amicus curiae due to my difficulty in determining exactly what were the various issues at large and the various concerns of Mr. Keane, being self-represented as to procedural matters. The matter came back before me on the 9th of February for a judge-alone trial. Mr. Keane sought to make his own recordings of the trial. I refused that application and pointed out that everything was recorded by the court system and that he could have a copy. I received confirmation that the recording system was up and running. The trial proceeded. One prosecution witness gave evidence. He was cross-examined. Mr. Chambers offered assistance which was not accepted by Mr. Keane. The trial ended. I sought written submission because I was still not sure exactly what was at large. Subsequently, as to my consternation, I was advised that despite the assurances I had sought as to the recording system working, and despite assuring Mr. Keane that it was being recorded, the system had not been activated and hence no record was taken. I called counsel and the defendant to a conference which resulted in the police consenting to the charges being dismissed, as a rehearing would not meet the public interest test, despite the police insisting they had a strong case. I have read the lengthy submissions which have been made by Mr. Keane, and also the submissions made by the police. I have considered them carefully. I have also considered carefully Section 5 of the Act as to what I must take into account when exercising my discretion. As to the defendant's applications for costs, his various appearances representing himself, I am satisfied, relying upon the Court of Appeal decisions in Merrick v.R., that Mr. Keane is not entitled to such costs, being self-represented. He can, nevertheless, claim disbursements to the terms of the Act. In this regard, I have been assisted by the decision of Gendel J. in Sanders v. Police and his references to other cases. Returning to the completing merits of the application, I can accept that there has been some procedural issues as to the disclosure, and that the disclosure has been somewhat piecemeal of a concern to Mr. Keane. However, that, on its own does not, in my view, resolve the issue, and I do not accept the police acted in bad faith. The case did not involve any trivial issue. The case did not involve any novel issue. The police case appeared strong. Mr. Keane, despite advice from Mr. Chambers, did not seem to appreciate the deeming provisions as to the identity of the driver. I do not accept that the various grounds put forward by Mr. Keane are sufficient either singularly or together to persuade me in terms of Section 5 that he should receive costs for his claimed disbursements. He, like any citizen, is entitled to pursue any technical defence, however small the ultimate penalty, and he is entitled to raise the procedural issues that have concerned him. I am not persuaded that when balancing the matters I am required to consider in Section 5, as I have said, Mr. Keane has made out a sufficient case for disbursements to be paid. The application for costs is declined. I do, however, wish to note that I do not accept the police submission that I have no jurisdiction to award costs.
It's been emotional.